Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to part 2 of Real Talk. Today we've been talking about people who may have assets and how those assets are calculated in the event that they become ill and need care or care facilities in a care home situation. And that is something that is going to affect many people, as it affected my family as well, my mum and my auntie a few years ago. And this is something that has been an issue that I've grappled with for quite a while. And not many people realize this, because most of the people from the Asian subcontinent have their own asset, in the sense that they like to own their own property. We believe fundamentally in having a bricks and mortars as one of our key assets. And in the event that a person finds themselves in a situation where they need care facility and care support and end up in a care home, the chances are that that asset may be lost to the family. The parents may want to give that asset as an inheritance to their children, but unless they do it in a way that protects those assets, the chances are that they may lose that asset and the children may get nothing, or they may get very little. So today I have a very eminent lawyer with me, Nasreen Karim from Platinum Partnership in Bradford, who has been on my program before. And we're discussing what can people do to try and make sure that they protect themselves from these charges. Now, if you have the money, subhanallah, why not? You should pay for your own care cost, and that is what Islam would want you to do as well. And you don't want to rob the state from what is their entitlement, but it is legitimate to try and protect those assets as far as you can possibly do so. And there are provisions to allow you to do that as well. And that's what we're talking. What are those provisions, and how can people protect those assets? And after all those times of working hard, building up a property of their own, wanting to pass that on to their children, that those wishes come true. So Nasreen has been very kind and very sort of telling us about some of the stuff that you can do to try and protect your asset. Nasreen, can we come back to this? And that is, you said joint tenancy in common. Now, obviously, that is a very complicated situation, isn't it? Now, tenancy in common, that means, do you then give up your right to the property by naming 2 people or 3 people as tenancy in common? Because one of my friends, is what they've done is, she's a single parent with 2 kids. They've grown up, they've sort of left the house, but she's now put the 3 of them as owners of the property. Is that one option?
That is an option.
Yeah.
Again, the share is being reduced so that it's a third each.
1/3 each, yeah.
Then it still depends whether that 1/3 share is worth more than 23,250, which it may be.
Right.
Because property price is quite high at the moment.
Mm-hmm.
So that may not be enough to protect. But tenants in common and joint tenants isn't actually that complicated.
Right.
You just have to remember that joint tenants, that share goes to the other surviving spouse. Tenants in common goes to the person named in your will. So yes, having additional parties, and you can have up to a maximum of 4 parties on the register, at the land registry, but you've got to bear in mind that it's got to be, that share has to be less than 23,250.
Right.
But tenants in common, it doesn't go to the surviving spouse. It goes to whoever's named in your will.
Yeah. Okay. And that's a very important point. I think people really need to understand this. Now, we've talked about why husbands and wives both need to be on the property register, because most people until now is usually been the male, the husband, who takes, it's my house, I bought it, and the wife doesn't appear on the register itself at all. But this is something new that, as Nasreen has shared with us, and that is tenancy in common joint, and that is something that needs to be absolutely understood. But the key point there was that you have to have a will, right, and name whoever the inheritors are.
Yes.
Now, how do you find our people? Are they sort of making wills? Because a lot of people I talk to, they don't even have a will at this moment in time.
It's surprising how many people do not have wills, even though they understand the importance of them. I made a will when I was 23 years old.
Oh.
It needs updating, of course, but that's how important it is. I was a single mum at the time, so it's really important for me to make sure that I had provision for my son. But it's so important, and people think about doing it later on, but you can't predict when you're going to pass away.
Oh yes, exactly.
You can't predict what's going to happen tomorrow if you become ill. So people try to put it off. You're talking about £250, £350 plus VAT. It doesn't cost a lot to make a will. You just need to think about sensibly, who do you want your executors to be? What do you have, and who are your beneficiaries? Who do you want to leave what you have to? It's as simple as that. But I think people put it off because they think it's going to be complicated. But
well, I think people feel that, I'm not going to die.
They think
people
they're not going to die. We'll do it later.
We'll do it later.
Yes.
Let me just, on that point that Naseem's mentioned, over the weekend we had a Sira conference in Batley. We had ulama from South Africa, very learned ulama, and other places. And one of the key points they talked about is to make a will is actually a sunnah of the Prophet ﷺ. He actually said that before you die, please make sure you put your house in order. And we have seen, and I'm aware of many, many families where the elder, the patriarch of the family has passed away and has not left a will, and there are squabbles taking place within the families. Actually, we're now seeing this happening in the Murdoch family as well. Rupert Murdoch's family is now in court fighting over who's going to take over control. And it's happening in our community as well. And you'll be surprised, people who are held in high esteem are going through these very difficult and challenging times where there is no will in place. So I would urge everyone to make sure you get a will. And as I say, it is a sunnah. The Prophet ﷺ, Allah bless him, peace be upon him, he actually said that people should make sure that they put their house in order before they pass away. So, as Naseem says, making a will is not a complicated issue. You need to think about what is going to be in the will, but the most important bit is who do you want to appoint to actually carry out the wishes that you put in the will, and that is the executors or the trustees.
Yes, it can be one or two people.
Yeah, okay. Now, obviously, £23,200, everyone who has a property will actually meet the threshold. So the best way of protecting those properties and making sure your children inherit what you've always desired to do is to probably go down the tenants in common route, if that's feasible.
And you can add additional parties as well.
Right.
So sometimes parents will add their children to it. I would never recommend that parents remove themselves and put the children on, because you just don't know what's going to happen in the future. So parents should be wise enough to think about themselves also. So I don't recommend elderly parents taking their names off for that reason. But one property can have one dad and two children.
Tenants in common, who then legally actually owns the property? Joint tenancy is very clear. If there's joint ownership is very clear. You nominate your son, your wife, or whoever it is, and they automatically become joint occupiers. In a way, but tenants in common. Well, will the person who actually owns the property in reality, will they still retain that power? So
it's similar the way it looks. So if the property is held as joint tenants, mum and dad, father passes away, goes to the mum.
Yeah.
Tenants in common, mum and dad own the property, father passes away, the person on the register who's the legal owner will still be mum.
Oh, right.
But she then has to pay that share to the children, whoever's been named in the will.
Right.
So the legal proprietor will still be the mother, but she will have to pay towards to the beneficiaries to make sure they receive their share.
When you say pay, what do you mean? Could she leave her share in the will to them then?
She could leave her share in the will to them as well.
Right.
But if the property is worth £100,000, father passes away, he owns 50%. He wants his share to go to his children. Mother has to give them £50,000.
All right.
For half the share.
Right.
She could do that. If she wanted to, she could add them to the property. So the two children, for example, or 3 or 4, however many there are, would own 50% of the property, and the mother would still retain 50%.
Right.
Or she could sell, or refinance, or do whatever she wanted like that.
Or on her death, it will then go to whoever's in the will.
And then on her death, it'll go to whoever's in her will as well.
And there could be the joint tenants as well, as beneficiaries.
Well, when mum passes away, there's only one registered legal proprietor.
Right.
So the property would actually physically and legally be transferred over to the children. So her name would no longer appear on there.
As I say, this is a very complicated area. and it's very complex as well. But it is going to affect everyone, whether you will like it or not. And it is absolutely vital and important that we get clear legal advice on, and maybe even accountants. I mean, there are some accountants out there who are well versed in this issue as well, and they might be able to give you advice as well. But obviously, at the end of the day, the property has to be legally protected. The title deeds of the property has to be legally sort of accurate, and therefore a lawyer is absolutely vital to this. Now, somebody comes up to you and says, Nasreen, I want to do everything you've said. Right? I want to put my property in a tenancy in common, for example, and I want to make sure that all my assets are protected as far as practically possible. What sort of average cost are we looking at in terms of lawyers' fees and things like that?
A few £100.
300?
It's a few hundred.
A few hundred, right.
Solicitors will vary in fees, but you're talking about a few £100. It's not an expensive job.
Right, okay. So if you have a property, and most properties now are probably worth over 150 to 200,000 pounds anyway, and you want to protect that 200,000 pounds, it's definitely worth paying 300 to 400 pounds to try and make sure that your legal process is in order. Now, can I just, sorry, go on.
What you've got to remember is, so if we have mum and dad and tenants in common, 50% share goes to the children, whoever's named in the will. Right. The 50% that's remaining will still be subjected to the means testing by the local authority. So it doesn't mean to say that you don't have to pay anything.
No, I agree.
But it's been reduced.
Yeah. So they will take charge of the 50% of the value of the property. And I think what most people want to know is how can you minimize that? Now, if you have husband and wife and 4 kids, and they make them sort of joint tenants, right? Would that reduce the asset in inverted commas of the individual?
It could. So again, the local authority would look at mum's share. Does she have 30%, 50%, 70%? So on paper, 3 people or even 4 people could own that property, but mum may only have a 10% share. Right. And the 90% could be 2 or 3 children, whoever it is. So most people probably don't know this, but when you buy a house, you sign a transfer deed, and the transfer deed is the transfer from the seller to the buyer. On the transfer deed, there is a question: do you want to hold this property as joint tenants, tenants in common, or do you want to hold as tenants in common? It's on every single document.
I wasn't aware of that at all.
That people sign every single day. It's on there.
All right.
Sometimes solicitors don't make them aware. Sometimes solicitors just assume if it's husband and wife. Generally, the rule is if it's husband and wife, tick the box for joint tenants. Right. If they're business partners or siblings or anybody else, generally tenants in common, because that share is then distinct from the other share. Right. So this is standard procedure on the transfer document.
What about putting properties in trust? That's something people were doing before. Is that still currency at the moment legally?
Anybody can enter into a trust deed. Right. So the legal proprietor would be whoever, but then behind that property is actually held on trust for whoever's named in the trust deed. Right. So that still does happen, but sometimes trust deeds, as you know, are questioned. So it just depends again on the situation.
And I must re-emphasize this, that if the local authority thinks that this has been done deliberately to try and avoid care costs in the future, etc., they could challenge those decisions and can go to court. And therefore, I think the general rule is that when you make these sort of arrangements, that if you live for 7 years, is it? In the old days, if you live for 7 years, then I think you have probably mitigated your property. If you die within 7 years, then I think different rules apply. Am I correct in that?
Not quite when it comes to trust deeds. So the trust deed would only kick in really when somebody passes away. Right. So I would say that's a little bit more complicated and open to suspicion.
Right. But as I say, the local authorities are now very keen to make sure that they get evidence to show that people are not really doing this to try and protect their properties from being charged for care costs, etc. So the sooner you do it and the quicker you do it, having consulted members of your family, the better it is for you. Now, if somebody wants to approach you and say, Nasreen, we want some more advice and guidance on this, they can contact you at your firm.
Yes.
Right? And that is Platinum Partnership on Manningham Lane in Bradford. But I'm sure you've got other colleagues as well that you may want
Yes.
to assist you as well. Now, as I said, a lot of people, and I think somebody, Mora, one of our colleagues here was saying that somebody phoned a few weeks ago and asked, who can give us advice on making wills. I know you said, you don't have...
We can do that.
You can do that as well.
Yes.
Okay. So I hope that, what you've heard and what you've learned, it's a break. I hope what you've heard so far is something that, resonates with you. We're going for a short break again. But Nasreen, coming back, I want to talk to you about lasting power of attorney as well, which is something that many people don't know about, and something that is absolutely equally vital and important in our community as well. And this is something where, in the event of you becoming ill, and where you become so ill that you cannot actually make decisions for yourself, you have let's say you have a stroke, and you lose your faculties, and you have assets, you have a property, you have a bank account, but you can't sign, you can't talk, you can't do anything with it. Who is going to be making decisions on your behalf? How? And I know in one case a man had all his assets and all his income in one bank account. The wife was not a joint accountee, and when he became ill and was not able to make any decisions, the wife could not even touch a single penny from that bank account because she was not part of the banking system. So in the event, what would happen if this happens to you? May Allah protect you from all this. So we'll come back and we'll talk about that, because lasting power of attorney there's two aspects to it. There's a health one and a finance one, and I'm sure we'll discuss with Nasreen and what are the best things to do in order to make sure that you don't get caught out on that. So let's talk about that when we come back. And this is something I know you've said that you've already done, and we can share your experience with us so that my audience can also learn from that experience and why you felt you have to do it. By the way, I've done it as well. I just need to register it. So don't go away. Inshallah, I'll see you soon. Take care. Assalamu alaikum wa rahmatullahi wa barakatuh. And if you want to phone in, please do so. We'd love to hear your thoughts. Take care.